Hi, this is Curt and welcome to another edition of Fire Law Roundup.
We're going to start with a settlement in Buffalo, New York, or we call them like 6 feet under snow. I mean, they have just got destroyed with snow. But this is a different issue. So in New York State, so everybody knows, and this will have ramifications, I think, for everybody. I think there's one or two good points to take away from this. So the first is that in New York State, starting March of 2 years ago, New York State legalized recreational marijuana. Now, that's not this issue before I even tell you what happens. But New York State, before that, had authorized the legal use of marijuana, or cannabis is the right term, cannabis products, for medically authorized or medically certified use. And so our listeners understand, probably in no state is marijuana or cannabis prescribed, because you can't prescribe it, because at the moment it's a controlled one substance. That may all change very soon, maybe. But nonetheless, so medical marijuana is certified. So here's what happened. So here you have a union shop where the city of Buffalo, very busy fire department, they are just running structure fires right and left, having nothing to do with this. But nonetheless, the city of Buffalo is unionized, of course, and they have a collective bargaining agreement. And the CBA predated, I think it was in 16, the CBA predates the legalized use of certified marijuana. Again, I can't stress enough, we're not talking about recreational use marijuana. So everybody in New York or the other 20 some odd states who have legalized marijuana, keep the issues separate. You cannot, I think, Curt, you would agree, you cannot evaluate the marijuana issues in a vacuum. You have to separate recreational use and certified or authorized use. And this is medically authorized or certified use. So we're not going to talk about recreational. So here, a firefighter used it for a condition. It was very clear when he went for a drug test. Listen, here's my card. I'm certified, used it, and they terminate him. And this is a very quick turnaround. So he initially moved to dismiss the case. I have not been able to read that.
The city moved.
I'm sorry. The city, the defendant, moved to dismiss it. The judge denied the motion to dismiss, and now they have settled. So look, on the facts, all that's happened is there's a settlement, and people settle for a lot of reasons, right? Either because we think we might lose, either because we don't want to risk losing, or, hey, we totally admit it, we shouldn't have done it, we're going to lose, so here's a payment. We don't know what that is, but it's a settlement, so there's no real law on this. But let's look at some of their obvious concerns. Some of the obvious concerns are, they argued unsuccessfully, the city argued unsuccessfully that, well, wait a minute, the CBA prohibits certain marijuana or cannabis use. That didn't persuade the court. So I think the biggest takeaway is, if you have a CBA in your local and it predated your state's authorization of medical marijuana, and almost, not every, but many, isn't it like 29 or 30 some odd states are now allow medically authorized marijuana.
We'll get to this, but there's an interesting nuance, because I would say this is a much more narrow case. Now, you're from New York, so sometimes when you're from a place, you kind of take it for granted.
Right.
But New York and Connecticut, and I'm not sure our law doesn't quite go as far as yours, but your law is different than most other states in that it basically protects someone from employment discrimination.
It does.
Who has that medical certification.
Right.
Most states don't. Most states that allow medical marijuana don't have that.
Okay, so we definitely do. We have it both in very expansively, and our laws, by the way, were modeled after Colorado, right? The originator of this.
Well, see, again, there's two parts. There's one is the medical marijuana part. Okay, the other is the employment discrimination part.
Okay. Yep.
Okay, and you might have modeled the medical part at it, but you and Connecticut are really way out in front of the rest of the country.
Okay. Well, New York has a good or bad, a long history, especially recently, of protecting workers' rights from activities. They are clearly here saying it is employment discrimination if you discriminate against somebody. And let's point this out. So notice this is in state court, not federal court. Under federal court, as we know from a case, city of Waterford, isn't it? Not Eckstein, Eckert, or there's a city, I think it's a Connecticut case where they sued in, and it was decided, I believe, in March of 21. I lecture on it. I got it from you, frankly, or from this thing.
It's a firefighter case.
It's a firefighter case.
Okay, yeah. Well, see, you and Connecticut are very similar, but
yeah,
the leading case in this area for most of the other states came out of actually Colorado, and they had medical marijuana. They had a couple of different things, and they legalized marijuana. But the person sued under the ADA. And the court said, wait a minute, it's illegal under federal law. The ADA doesn't give you any protection.
Because it's a controlled one substance.
Because,
right? That's why I think they're in state court as opposed to federal court, because they knew they would lose under the ADA because it's a controlled one substance. Yeah. And, Massachusetts, in a case called Barbados, takes that other view, that I guess what you would say is the majority view, saying, hey, we don't care. Well, no, I'm going to flip that. They take a very protection view of the employee saying, we don't care. It's legalized so many places. We're not going to allow somebody to fire you because you use it for medical use. So they took, and that was back in 17, that case. They take a very employee protected view. New York does the same thing. So under New York's law, they say, we don't care that it's illegal federally. We want you protected for certified use, which again, lawyers drive themselves nuts. I mean, going way back to Gibbons v. Ogden and all these cases where we're saying, wait a minute, interstate commerce, we know this is interstate commerce. The United States Supreme Court held this is interstate commerce. So anything that's interstate commerce is governed and preempted by federal law. And yet states here are like, you know what? We're in charge, not the federal government, which is amazing to me. But nonetheless, all that happened here is they settled in state court under a certified medical use. But I think they didn't want to challenge, because I would like to, how federal law doesn't preempt when state law says, right, it's legal and federal law says illegal, how state law grants you rights that federal law took away. Nobody wants to address that. The United States Supreme Court should address it. It doesn't seem to be getting anywhere, even progressing through the appeals courts. I don't think anyone has said anything. Instead, what's tactically going to happen, just for everybody understanding under marijuana, there are three important things that are happening federally, which is going to make it easier for lawyers, not easier for employers. The Biden administration is decriminalizing marijuana. That doesn't affect the employers, but it's always step one. We decriminalize marijuana. Every state has gone that path that eventually legalized it. The second is the MORE Act, which is in the House of Representatives, to remove, basically it would remove, order the FDA and the ATF from, it would force them to remove actually DEA and FDA to remove marijuana from the controlled one substances list. And the third thing, which I just saw might happen, though it's going to be very tough if we cross January 1st with the new House, they are trying to get the what's called Safe Banking Act, where they can allow banks to utilize money derived from the sale of marijuana. Right now, it's got to be cash transactions or otherwise. So those three things are moving towards the legalization of marijuana at the federal level, which will make this easier. Right now, what we're seeing is exactly in New York. Hey, we're going to sue in state court, stay out of federal court, because we know that's not going to go well for the employee, that they'll be employer sensitive. And we're going to use New York State's law, which is clearly preempted by federal law, but no one seems to care at the moment. And that's where we are. So I think, as you said, every state is maybe in somewhat different in many ways. New York, Connecticut, and I think Massachusetts may be in the minorities. So you can't expand this too much. But I think one big point is with your CBA, you better look to see what your state law has done with regard to medical marijuana and make sure your CBA is updated after the date of that law to reiterate what you want. And I think most unions and employers want marijuana use made impermissible.
Yeah, and I understand how things like that can get overlooked. The gray hair I have in my mustache is primarily due to union related activities and negotiating and that kind of thing and strategizing. And one of the challenges is you go into a negotiation and you have certain priorities, and fixing language that might have been in the contract for 20 years is just not a priority. Like, you're trying to get a raise, you're trying to get this, you're trying to get that, maybe some pension and healthcare, and the city's got their issues.
Yep.
And nobody wants to give up anything just to straighten out some language. And so it's easier, especially as contentious as contracts can be, nobody wants to address it. And now you find yourself with language that is outdated, and now it's creating a problem. And so I understand exactly how it can happen, but it's something that needs to be addressed, like you suggest.
And that's the lesson from this case. But I want to be clear for everyone saying, oh my God, how can you allow marijuana on duty? This is not on duty. This is not recreational. And I didn't mention this. He was very clear. I do not use on duty. I'm replacing another drug, which has worse effects while I'm off duty. So I replace it with marijuana. I do not use marijuana on duty. He's very clear about that. So this isn't necessarily a direct safety issue of on-duty use for any purpose. So, but marijuana is going to change this year or not. We're going to find out. We'll see what the Republicans will allow to happen out of the House. So we'll see.